today, like I was saying, purely about education. Okay. So we don't know what we don't know. And I really, really enjoy sharing this piece with women because it's a daunting piece. It's an intimidating piece, right? I often say us as legal professionals kind of drop the ball on educating the population about estate planning because it's something that every family needs, whether you have $500 or $5 million, right? And so the goal here is, when I talk about estate planning, I say it's misunderstood, poorly understood, not understood at all. And so we get to make better choices for our families when we understand what estate planning means, right? So real quick to share about me, I've been practicing for 18 years. This is my family, my husband, Anu, and then I have two daughters, Asha and Anya, who are third grade and first grade. I used to be a partner at a law firm. That's usually where most, it's kind of like in the world of medicine, right? That's kind of where you kind of stop and park your career. But about 3 years ago, I decided to start my own firm, and it's very education driven. And I speak to groups all the time. We're both a estate planning law firm and a business law firm, and our model is this. Our model is teaching folks about the basics of the law, and the more informed you are, the better choices you can make for your family and your business. And luckily, our model has been well received, so we have really great reviews from our clients. Okay, so today, like I said, we're talking about estate planning. We're going to talk about the basic building blocks of estate planning. The basic building blocks are essentially what is a will, what is a trust, what makes sense for me as a family, what model makes sense for us based on our asset profile, our family profile, how do we best pass on our assets. There's a tax component to it as well. So we'll talk mostly about the basic building blocks, but estate planning can also be taken a step further. This is kind of where you just have to figure out what's right for you and your family, right? The more we know, the better choice.
I didn't see her.
And
When did she leave? She just left?
Okay. And if you're talking, if you could just mute, that would be great. Some of us might have young minor children, right? If we have minor children, we have to make a plan for our minor children because otherwise the default is foster care. Everything I'm going to say today, just so you guys know, there's a solution for everything. Estate planning, like you guys as physicians, estate planning is about being proactive and intentional, right? If we can be proactive and intentional and preventative, we can make better choices rather than, oh, now something happened and it's reactionary, right? Now we're having to fix a problem. So the goal is being able to know enough to make those choices that make sense for our family. So how do we protect our kids? How do we protect our dollars? And then if we want to take it a step further, how can we be really savvy with our taxes? How can we build in tax strategy, build in asset protection, things of that sort. So we can definitely talk about that. When it comes to estate planning, like I said, it feels very heavy. I like to tell people, I think of estate planning as a plan for life, not for death, okay? So when we make choices that protect our family and protect our people, that buys us the peace of mind and the comfort. A good estate plan takes 4 big pieces into account, okay? So there's your assets, that's your dollars, right? Your dollars, everything you have in your bank accounts, your home, and so on. Your family, how are we going to take care of your family later, especially if we have young kids? How do we make sure our young kids don't end up in foster care or end up being taken care of someone who maybe we don't want to be the guardian of our children? But even if we don't have young kids, for our family, how do we make sure the dollars are going to the right people? How do we make sure that inadvertently they're not going to, the creditors or the government, or if our children get married and then they get divorced, the automatic way that a plan works is the divorced spouse gets half of it. How do we make sure those things don't happen? We'll talk a little bit about our own personal comfort. That's where we talk about things like powers of attorney. And then if you happen to be a business owner, also, how do we make sure all those dollars from your business flow in to your estate, okay? So just so everyone knows, many times people will say, I don't have any documents, I don't have a plan, I have nothing. The state of Texas actually has a plan for everyone. So even if we don't have a plan, the state of Texas has a plan. And often that plan is not the plan that people want, okay? So we'll talk through that. We'll talk about what is the default plan for everybody. And then if that plan makes sense for you, that's great. If that plan doesn't make sense for you, then what do you do to plan around it, right? So colloquially, when you hear about estate planning, you'll hear people talk about a will, right? Everyone says, oh, I need to get a will, I need to get a will. if we have no documents or if we get a will, even if we create a will, the default for administering that will is something called a probate process, okay? That's a court probate process. So even if we have a will, our family has to open and file a court case called a court probate process. You'll see this graphic. This is basically the process of probate. It's very multifaceted. In general, a probate process is designed for the benefit of creditors. And a lot of us on this call may not have creditors, right? But because it's a blanket process, there's two big reasons for probate. The first is to notify creditors, hey, this person passed away. If you think you have a bite of this apple or a claim on this estate, show up on this date to this room and make your piece. Say what you think you are owed, right? Because of that, the probate process is very public. To this day, they still make us file it in the newspaper. They make us file a death notice and notice of probate in the newspaper saying, these people passed away, show up on this date at this time before this judge to say what you think you may be owed. And there are people that professionally do this, right? It is public to the point where they don't let us file any of the assets under seal. And this is something that often is a surprise to a lot of people, but every dollar you own, where that dollar is parked, who you're giving it to, when you're giving it to them, all of that is public, right? So it is an airing of your financial laundry. Everyone sees who you're giving your money to and when they're receiving it. Assets also get tied up and frozen in the probate process because we can't give anything out until the court says, okay, there's no creditors or no one else you need to give money to. So when assets get frozen, our families can't take anything out, right? So it's a public process, assets get frozen. You have to hire a lawyer to walk you through this process. It can get pretty expensive. It can be up to 5% of all the assets that you own. And then there's just a lot of pieces that you have to do. And then you end up retitling the assets from your name to your kid's names, right? So quick summary of that is probate. Even if you have a will, you have to go through the probate process. Everything becomes public information where all of your dollars are. The court's involved in every step. A judge and a lawyer have to sign off on everything. Assets are frozen. Distributions aren't made until a judge orders it. It can be, again, up to 5% of your assets. If you happen to have a home in California or Florida or somewhere else, you have to open 2 court processes in each of those states, right? It can take a while and it can get pretty expensive. So again, everything I'm saying today is, it's not meant to come from a place to alarm. It's really meant to come from a place of education, right? Like it's just good for us to know these are how these processes work unless we make other choices, right? So if we have young kids in America cannot inherit until the age of 18. So if we don't have our documents in place, then the court gets to decide who's going to be in charge of our kids' dollars and who will decide what they get money for and don't get money for. And then they get their money at the age of 18. We don't know who that person's going to be that gets appointed as our kid's financial guardian. And at the age of 18, they basically get all of their money outright into a bank account. Okay, so that's just, again, this is just kind of like the default process. Something else just to be aware of is there's something called the Department of Unclaimed Property in Texas. A lot of people don't know what their families own, right? Like when I did this for my parents, I had no idea that they had annuities and little CDs all over the city of Houston, right? It was everywhere. If we don't know what our families own, the default is that all of those dollars go to the Department of Unclaimed Property. That's already over $8 billion, primarily funded by people not knowing what their families own, right? So again, so this is the standard process. The standard process is that we have to go through this court probate process, open it. It can take a while. Our families have to go through the court process. It can get dragged out, assets get frozen, right? Okay, so I share that just as education, but because that process in a lot of ways is suboptimal, because it is something that a lot of people don't want their families to have to go through, the legal process is designed a way around it, okay? And that answer, which many of you have probably heard of on this call, it's called a living trust, okay? This is the legal system's answer to saying, hey, every family should not have to go through the court probate process. Every family should not have to have all their assets made public if they don't want that. Every family should not have to have their dollars frozen if they want immediate access given to their kids, right? So this, if you want the privacy, the flexibility, the immediacy of funds being transferred, that is what a living trust is. A living trust is essentially a substitute for a will. It allows for us to completely bypass the court's involvement. So how does a living trust work? You just saw, that snaking graphic, right? That had multiple steps involved for the court probate process. A living trust is much, much, much simpler. All you do is you essentially take all of the assets that we have now, and we put them into something called a living trust, which is tied to your social security numbers. So to be super clear about this, it's just tied to your social security numbers. There's no additional tax ID numbers, no additional tax returns, no additional financial implications. We just take everything and we say, okay, we'll change the beneficiaries on it to be Arati's Living Trust. We, move the house to Arati's Living Trust, right? We move everything over to something called a trust. So it ends up being almost like a consolidation vehicle. And now, if and when we were to pass, everything just naturally flows down. The court is not involved. It stays completely private. It's a one-time thing, stays private, and all the dollars flow to our beneficiaries. We don't have to file anything anywhere. It happens immediately. And then if we wanted to, there's additional things we can build in, such as, again, asset protection, tax protections, and so on and so forth. So again, the way that the trust typically works is we put all of our assets into the trust, we change beneficiary designations into the trust, and everything becomes immediately available to our families. In general, again, the trust allows for privacy, flexibility, bypassing the court's involvement, and then if we want, building in asset protection, tax protection, so on and so forth. It can be as simple as we want it to be, which can be as simple as, I just don't want my families to go through the court process. I want this to be simple for them. I want them to be easy for them. Or it can be along the lines of, hey, when my kids get married, I want to make sure, I think I mentioned this earlier, I want to make sure that when they get married and then they get divorced, they don't, or if they were to ever get divorced, I want to make sure they don't lose half of it, right? Or, hey, if my kids make a risky business decision, how do I make sure that they won't blow all of the assets that I've left them? Or maybe it's, hey, my kids are too young. I don't want to give them $5 million outright. How do I make sure that $5 million doesn't go to them immediately? How can I maybe guard against financial immaturity or almost protect them from themselves when they're younger, right? That's something that the trust will allow you to do. It allows you to guard against maybe opportunistic parties or guard against financial immaturity when our kids are younger. Okay, so I am actually now going to switch gears. Like I said, there's many different pieces, and this is kind of a quick piece on the asset side. If anyone has any questions on this piece right now, let me know. Otherwise, we can take questions at the end. But this kind of speaks to the wills versus trust piece. Okay, so I'll move on and then I'll take questions at the end. So again, when we talk about an estate plan, we talk about assets, then we talk about family and so on and so forth, right? So this is the asset piece. It's making the first initial decision of, do you want a will or do you want a trust, right? That's how that works. The next thing we'll talk about is guardianship, okay? Guardianship is when we're talking about having young children. We have children under the age of 18. We have to appoint guardians for our children, okay? I don't say this to alarm you guys, but I say this to educate you guys. If we don't name guardians for our minor children, the default is foster care. And I know that sounds extreme, but it's because if we think about it, if something were to happen to us and our spouse, right? If we were in a car accident and let's say like grandma showed up, or let's say an aunt showed up or grandma showed up, first responders would never know like if that was a safe place for your child to go, right? First responders would never know that was safe. Oh, if you can just mute your call if you're joining, so we just don't hear the background noise. So yeah, so first responders would never know if it was a safe place for your kids to go or not. So what ends up happening is your kids end up going into the state's care, right? And then you have to find a spot on a judge's docket. So maybe that's, 2 or 3 weeks away, and then there's a hearing and there's a lot of testimony that's being considered, right? So then, grandma speaks, aunt speaks, all these people speak, and then eventually the court will decide, okay, where does this child go, right? So to avoid the court process, what we really should do is we should really name guardians for our kids. I know this is one of the hardest things for parents, and I understand that because I am a parent myself. This is obviously a hard thing to do. No one will ever be as great as you will be, absolutely. But if we don't make this decision, the court will make it for us, right? And so for parents that struggle with this decision, I have kind of a process to work them through to kind of get them on the same page and figure out who the best guardians are for them. I usually will always say when we're naming guardians or figuring out who our guardians should be for our children, the things we should consider are people who are like ideologically aligned with us, value aligned with us, a home that makes sense for our kids to be raised in, right? Those concepts make more sense than, oh, does this person have the financial means? Because remember, our kids are going with buckets of money, essentially, right? And your dollars will always be able to feed your children and the family that needs the extra dollars. So for example, if the family, that you name needs to move into a bigger house, there will be dollars in your trust or in your estate that can help pay for that. If we need night nannies, if we need au pairs, all of those things your dollars can pay for. So I always usually will advise that, hey, when we're picking guardians, have it be someone that just feels like a natural extension of like the values of our family, because everything else we can accommodate for. Again, just generally speaking, if we don't make these choices, the state makes them for us, right? So even though there's no perfect choice of who it will be, we usually can make a better decision. And I'm always happy to kind of talk through options than the state would make. Okay. Something else we do at our firm is, for example, if we pick guardians that end up live in New York or California or Pennsylvania, right? Before they can get here to the Houston area or where we are, before they can get here, the default will still be foster care until the guardians arrive. So we actually do something called short-term guardians and long-term guardians. So short-term guardians are people that live within 30 minutes of us who can step in and hold on to our kids essentially until the long-term guardians arrive. And that's, again, important because just given the scenario, we want to make sure that our kids are accounted for. So we have short-term guardians and long-term guardians, okay? So now we've kind of spoken about the asset piece, and then we've spoken about the kid piece, right? Both very important parts of the equation when it comes to estate planning. Then there's a piece about us, right? So most of estate planning is about our family, taking care of our kids, taking care of our assets, making sure they go to our family, having that legacy that we want, making sure they're accounted for. But there's a piece about us, and these documents are also really, really important. A financial power of attorney. That is who we are giving access to our bank accounts when we can't reach into our bank accounts ourselves. So if we happen to be incapacitated or in a coma, who we pick as our financial powers of attorney are people who can reach into our bank accounts to help us keep the lights on, pay our mortgages, so on and so forth. Healthcare power of attorney, you guys are familiar with this. Who can speak at our bedside when we can't speak for ourselves, right? And then the health directives and the living wills. How do we feel about life support? How do we feel about organ donation and so on? So while most of estate planning is about other people and our dollars and our family, there is a piece about our comfort, right? We're obviously, a lot of us on this call we're familiar with the idea of, just incapacity planning in general, right? So financial incapacity planning, but also, things like the Terry Schiavo case, right? How do we make sure that our wishes truly are honored and our wishes truly are granted, right? Again, that is done through effective incapacity planning. Okay, so I will wrap this up here in a second, and then we'll take questions. Big takeaways. I feel like we covered a lot of ground today, and we can break it down into smaller blocks if we need to. If we happen to have kids, our young minor kids, our kids are our most important asset. I get really protective of making sure that we overpaper the file when it comes to young minor children. Guardianship, again, no one will probably be as great as us, but if we don't make these choices, the court makes it for us, right? So who are we picking in those roles? For every guardian role or power of attorney role that we name in our plans, we always pick one person with 2 backups because we don't know how life will work out and we want our documents to work when we need them to. So one guardian, two backups, long-term guardians and short-term guardians, right? How do we make sure that the kids are accounted for? Another important piece then is the asset piece, right? So today we talked about wills versus trusts. Wills don't avoid probate. And again, most people don't even realize like that's how a will is administered. It means you have to go through a court process. It means that court process has to be public. It means everyone sees our dollars. It means it's a huge expensive process, right? And it can get dragged out for 6 months, 9 months, a year. The living trust is the legal system's answer to bypass that process, to avoid the court's involvement with zero court involvement, to allow for privacy, to allow for your family to get immediate access of your dollars, to allow for control. We didn't talk that much about this, but when you're doing an estate plan, make sure your estate plan can kind of stand the test of time. Okay, that's important. Many times I'll have new clients come to me and they'll say, oh, we did these documents, but we did them in the 90s, right? Or we did them, 15 or 20 years ago, right? When we do documents that long ago, things obviously can change, right? Our asset position changes, our asset position, our financial position changes, relationships change, things change. How do we make sure our plan works when we need it to work? With all of our plans, we just do kind of a flat fee. With all of our plans, we do complimentary check-ins at least every 3 years to make sure, hey, are your relationships still the same? What's going on with your assets? Have things changed so that we need to account for things differently? That's really, really important because if your plan isn't going to grow with you, it will become stale and it may not work when you need it to work, right? So you want to make sure that you're checking in on your plan and just doing general plan maintenance at least every 3 years, just to make sure, again, it does what you intend for it to do. Another thing that's really important that you should make sure you're doing with your estate planning, with all of our clients, we do a comprehensive asset inventory. This goes back to what I was saying about the Texas Department of Unclaimed Property. If our families don't know all the assets that we have, and if we don't have those compiled, and if we're not continuing to maintain that inventory list as our assets grow, the default will be that they go to the state. We obviously don't want that, right? We don't want our assets to go to the state. Something I didn't mention yet on this call, but my guess is for a lot of us on this call, if we don't already have an estate tax issue, we probably will have an estate tax issue at some point in our life. I feel like that's probably a fair guess. So what does that mean, right? That means after a certain threshold, so right now, let's just say the number is 5 million, okay? And the way that 5 million is calculated is it's the full value of your home without a mortgage note against it. So if you have a $2 million home, it's the full 2 million without the $1 million note on it, right? Life insurance is counted in full. All your IRAs, your retirements, your bank accounts, your brokerage accounts. After we get to 5 million, everything above that is taxed at 50%. Okay, so that's an important thing to realize and to note. And that's, again, another reason that estate planning is so important. We have solutions for everything, but we just have to be proactive and intentional. Okay, so for example, going back to that 5 million piece, if you end up passing away and you have an $8 million estate, the 3 million above the 5 million gets taxed at 50%. So that 1.5 million tax now is going to the IRS. It's not going to your family. Again, we have tools for all of it. We just have to be proactive and intentional and plan. Again, kind of like healthcare, right? We have to be preventative. We have to be proactive and kind of get ahead of this, right? Because the planning, I'm a firm believer in this. There's answers for everything. The more we know, the better we can plan for our family. But it keeps us in control. Actually, in the long run, it's a huge cost savings because we're not having to pay the courts and the lawyers hundreds of thousands of dollars, right? So when we design, we get to design for what makes sense for us as a family, for our kids, for our assets, for where we are on our wealth trajectory, right? So again, even if you don't have an estate tax issue now, that's why with all of our plans, we're checking in every 3 years because one, along with just assets changing, relationships changing, making sure the plan is working the way you need it to work, we keep a really close eye on that estate tax value, right? So if we're inching towards that value where all of a sudden, oh, everything above that is going to be taxed at 50%, what can we do to keep those dollars in the estate and not have it go to the IRS? Again, there's tools for everything. We just have to stay ahead of it. Okay. As far as us as a firm, all of our work is custom designed for you guys and your family. And we do all flat fee work. Promises that I make as our firm is We don't offer anything unless it's the right size solution for you guys. It has to be custom designed to specifically where you are. We don't offer anything that doesn't save you hundreds of thousands of dollars in the long run. We make sure that it's going to save you a ton of money before we ever offer it. And then we're also not a one and done in that, yes, it's a one-time investment, but we make sure, hey, when something actually happens, we always hold the documents for you. So we always have an electronic copy and we help roll it out for your firm. Okay, so today really was purely about education. So I just want you guys to be educated, and I want to take all the questions that you guys have. But if anyone is on this call and it's like, hey, I really should probably get this done for me and my family, I'm always happy to have that conversation with you guys. And so the way that our firm works, just so you know, is we don't charge for our sessions, because again, that's where we do a lot of the ideating and the educating and so on and so forth. We just charge for the work that we do, right? So it is all flat fee. The way that we do it is, again, if you're like, hey, I really want to learn more, I want to figure more out. We have these life and legacy planning sessions, which are 2-hour sessions, which we don't charge for. And to have that session, I have you guys fill out a worksheet. Takes you about an hour. I get a really high level sense of, hey, what do your assets look like? What does your family life look like, right? So you've done your homework for me. Then I spend some time reviewing that and making sure I can really kind of identify what makes sense for where you guys are and what solutions would make sense for you. What are the right size solutions that would make sense for your family now? And then kind of have a sense of what that trajectory of your family is going to look like as, you know, as the years kind of pass on. So, just in general, that's kind of how we do things. Again, today is purely about education, but I just answer these questions because I end up getting these questions a lot. Everything we do is flat fee. So, you know, our wills plans start in the 2000s, our trust plans start in the 4000s. The 4000s will keep you out of the court process. It'll keep you out of probate. If we want to build in additional tax planning, advanced asset protection, protect the dollars for our kids, protect against creditors, protect against lawsuits, protect against malpractice, insurance claims, so on and so forth. We can do all of that and create a more sophisticated plan. Our advanced planning options can save millions. Our most basic trusts can save thousands. Again, a lot of this is just to do the planning, right? The planning keeps you in control. It ends up being a huge cost savings. And once you do it, you're kind of done, right? This is a one-time thing that you do, you put your energy towards, and then after that, we're just doing maintenance to make sure, hey, the plan's actually working as you need it to work. But really, it's just a one-time thing. And everyone in America needs an estate plan because, again, the state of Texas has a plan for you, but it's not a great plan. And anyone that's ever gone through the probate process will tell you that this is stressful. This is not fun, right? And then with all of our plans, we do something called an ever after plan. This is, again, this is free. This is something we throw in because we're very, very protective as a firm about young children. So this is where we're doing long-term guardian nominations. We're doing short-term guardians. We create wallet cards for first responders. So worst case scenario, they know exactly who to call. We actually do powers of attorney for minor children. If something happens to you and your spouse, we make sure that that minor child can get the medical attention that they need. So, okay, yeah, again, we're happy to do a complimentary meeting with anyone on this call. We don't charge for our time. This is just something that we, again, just want people to do because if we don't do it, it's much more involved, right? If we don't do planning. So happy to have a call with anyone who wants to. And now I'm actually just happy to open the floor and answer any questions that you guys have. Because, you know, I'm sure there are some questions and I will answer anything and everything. So feel free to ask away.